Okay, we're going to reconvene. I believe Mr. McElroy and Mr. Walker can at least address some of the concerns and questions that came up tonight now. So I'm going to give them that opportunity to do that.
Thank you, Mr. President. These are in no particular order, and if you have any follow-up questions or any council members have follow-up questions as I go through this list in a haphazard way, just jump right on in and let me know what you'd like me to clarify or follow up on. There are a couple of general things that have come up, themes that have come up repeatedly that I want to respond to. The first is that for some reason, some people have gotten the idea that there is a November 1 pressure point or deadline, or that Invenergy has somehow pressured us to decide this or vote on this by November 1. I've been doing the negotiation. I've been working with Solicitor Nicolaisen, and I can unequivocally state that Invenergy at no time ever pressured us to put this on the agenda, to do it by any particular day, including November 1st. I've never heard that date until I came into the room tonight. So there is no pressure coming from Invenergy whatsoever to do this, and they have never said to me that if it's not done by a particular day, they're going to pull it off the table.
I can second that. I haven't heard that date before tonight.
It was repeatedly stated that Invenergy asked the EFSB for a 90-day delay, and they got it, and EFSB gave it to them. That's not what happened.
That is what's happened. I was there.
Okay. Yep. Let him speak, please.
What happened is they asked for a 30-day delay in order to get a water plan together. The 30 days came and went, turned into 50 days, and they didn't have a water plan. We were in front of the EFSB on a completely unrelated matter, and the EFSB, the legal term is sua sponte, that means on their own, out of the blue, raised the issue of possible suspension of the consideration of the application because they did not yet have a water plan and more than 30 days had gone by. And so Commissioner Coit said, I want to issue a show cause order against Invenergy, requiring them to come in before us in the next 10 days to show cause why we shouldn't suspend their application from being considered. And that's what happened. The show cause order was issued. They showed up at the show cause hearing, and they showed no cause. And as a result, the EFSB then decided to suspend their application for 90 days and also to impose on them a 60-day reporting deadline so that they would have to come back in after 60 days and report where they were with the water, at which time the EFSB would take a look at it, decide whether it would go out the full 90 days or take whatever other action they felt was appropriate. At no time did Invenergy ever ask for 90 days. This was the EFSB imposing a suspension on them. And I want to point out that most people don't seem to understand what a terrible thing it is for Invenergy to be dealing with a suspension of the consideration of their application. As I mentioned in my statement, they have to come up with $12 million in January. Their investors, mostly their lenders, are going to be asked to put up that $12 million. If they're in a position where their application is under suspension in January, they may not be able to get their money for that payment. Now, I don't know their financial situation. I don't know whether or not they're going to be able to persuade their lenders, if it's under suspension, that they'll still give the money. But I can tell you, if I was in Invenergy's shoes, I would be very, very concerned that my application is under suspension and that my lenders are about to pull out from under me. So that wasn't the win we were looking for. We were looking for dismissal of the application, but it was nevertheless a win. And it was not something that was given to Invenergy, it was something that was imposed on them.
We're not doing any more public comments.
I'm sorry, Jason.
Because that's not how...
If any of the council members don't understand anything that I'm saying, such as what is the difference between suspension and dismissal of the case, I'm happy to explain it. Just let me know. Anything that I talk about, just let me know. Another question that has arisen is why does this need to be done now? It's my advice, and it's Mr. Walker's advice, that it should be done now. We've been negotiating this for a year and a half. We started in the summer of 2015. We essentially had this pretty much worked out weeks ago. What we've lost is, if you look at the various drafts that we've gone through under this agreement, we've lost the initial payments. And the initial payments have been pushed and pushed and pushed. As a matter of fact, I'm sure you've noticed under the agreement as it currently stands that there is a payment upon signing, but there was also a payment due about a week ago. Now, I've confirmed with Invenergy that they will, in fact, make that payment if the agreement is approved. And they're standing by their word on that. But we're getting into a position where we're going to start either losing the payments, the upfront payments, which some people think that's perfectly fine, go ahead and lose it. But I'm still going to be submitting my bills every month, and the expert engineers that we've hired are still going to be submitting their bills every month, and they're going to have to be paid. And if there is not a fund from which to pay them, we will not be able to continue to aggressively and relentlessly oppose this project. I'm certain of it. Now, the other problem is we will lose our negotiating leverage if we delay to the point where, as some have suggested, we wait until the 90-day suspension is over, and then Invenergy comes up during that period of time with a water plan. They persuade the EFSB that that plan is sufficient to allow them to reopen the docket, and the docket gets reopened and starts moving down the path. We've got to remember that the 120-day period starts up again, and most of it is already gone. What I'm saying in the bottom line is this thing will be moving very quickly when the suspension is lifted, and we will have lost the significant leverage that we've had throughout this process to get them to agree to this. They will have very little incentive to either give us the upfront payments or to agree to a tax agreement as generous as this one if all of a sudden it looks like they're on the verge of getting approval from the EFSB and getting their water lined up. This is a very lucrative package. It's one of the best I've ever seen. I don't think you should walk away from it. Both the upfront payments and the upfront fees and the tax payments later on are incredibly generous. It was a hard-fought negotiation. I can tell you that when we first sat down with them, they were offering about a third of what we eventually ended up with. And much of that is due to the good work of Glenn Walker, who's done so many of these agreements throughout New England and knows what the true value of this plant really is to Invenergy, especially in terms of the cash flow it's going to generate from its ISO payments.
Along that line that you just mentioned, that's a good point. The question that kept coming up is that the application is lacking information, and people are analogizing this with a house that hasn't been built yet. How can you assess, a tax rate on a house that hasn't been built yet when you don't know what it's going to look like?
Yeah.
So now might be a good time to explain how you assess a valuation on a power plant.
A power plant is primarily valued on the amount of cash flow it generates. We had a slide on that talking about the financial considerations. The way they make money is they get revenue through capacity payments from ISO New England and energy payments. And the way an appraiser looks at this, do they look at the property and see how much has been built? Yes. They look at the quality of it? Yes, they do. But in general, a natural gas-fired power plant is a natural gas-fired power plant. And in general, it's got a valuation range based, in the early years, the first 1, 2, 3 years, based on its construction value. But going forward, the value is the revenue stream that is coming in. So we can tell, A, because we know what it costs to build a gas-fired power plant, there are statistics on that. And so we've got that guidance. And B, we know what their revenue stream is going to be because we know what their capacity payments are. They've been awarded by ISO New England. We don't yet know what the second one will be, which is why the second unit tax payments are a sliding scale, because it depends on what ISO awards for the second unit, but we've covered that in the agreement. So we've got a fixed amount for Unit 1 where we know what the ISO payments are, we know what it costs to build a plant of this type and size, and we've got a sliding scale 1 for the rest of them. That's how that works. That's how the valuation is done. We don't need to see whether they're using architectural shingles or not. It doesn't really play into the formula. Again, in no particular order, I'll go through these and feel free to jump in at any time. There were a lot of questions about whether or not we're dealing with the right entity. Well, if we're not dealing with the right entity, which is Clear River Energy LLC, then you've got a gigantic legal malpractice suit against me. And I certainly hope that you don't. The reason we're dealing with Clear River Energy LLC is because they are, and these are the words of the EFSB, Clear River Energy LLC is the project company for Invenergy. They've been identified as such in all of the application documents. The EFSB has recognized them as that, and so Clear River Energy LLC must be the project company. The project company must be the owner of the property. Since we're dealing with taxes which are assessed against the owner of the property, the person on the entity on the agreement must be the owner, and that is Clear River Energy LLC. So we definitely have the right entity. There's no question about that. There were questions about how are we going to make sure they perform the agreement. Well, if they don't perform the tax agreement, we have the heaviest hammer that exists in law that I'm aware of, and that's the municipal tax laws. The municipal tax laws are set up in such a way that a town or a city's ability to collect taxes is prime. It's in first place over virtually anything else. Mortgages, it wipes out mortgages. Liens, it wipes out liens. Judgments, it wipes out judgments. It does not wipe out easements and restrictions, but those are not debts. It wipes out any other debt this entity might have. Now they're going to build the first unit plant that's going to cost them $400 to $500 million. If they don't pay their taxes, which would be $4 or $5 million a year, we can seize a $400 to $500 million plant. We are always covered hundreds of times more than we need to be. It's more than enough. It's the heaviest hammer in the law. Ask anybody who's lost their property to a tax lien, and they'll tell you. As a practical matter, it's also important to note that almost never would a property actually be foreclosed on for a tax lien. This property is going to be heavily invested by lenders. The lenders would never let a municipal tax lien prime their mortgage. So the minute you notify the lender that Invenergy or CRE is in default, the lender writes you a check every single time because they don't want their mortgage wiped out. Would you want a $100, $200, $300 million mortgage wiped out for a $3 million tax payment? You wouldn't. In the real world, it never happens. You will get your tax dollars. That's a guarantee. There were some claims by Mr. Craig that we can't make the warranties and representations in the agreement because there is pending a legal action challenging an open meeting relating to a previous vote this council has taken dealing with the proposed Keeble bill. Those two are not connected. There was a lawsuit filed today. Attorney Nicowishin may want to comment on it. He successfully defended it today. Justice Leach said he saw no connection between your vote and the vote on this agreement, that they were two separate matters, and he denied the request for an injunction. If you have the meeting, the only request in that suit was that this meeting not go forward and that the agreements not be signed. That's what was asked for.
That's absolutely correct. In the case from speaking to the other opposing attorney, that case is over. They're not pursuing it.
So the reality is this meeting was not enjoined. It was held. The only thing they wanted was for it not to be held. And so legally what has now occurred is that lawsuit has become moot. And we can go in at any time and move to have it dismissed if they don't voluntarily withdraw it. I don't think that prevents us from making those warranties and representations because It has to be that there is a pending lawsuit that could impede our ability to perform. Well, now that lawsuit is moved. It does not impede our ability to perform. There was some talk about the property value guarantee agreement and how the appraisal process works. Again, I want to emphasize, nobody needs to use that agreement. It's only a form that we negotiated on your behalf. If you want it, you can negotiate your own transaction. If you don't like the way the process is set up, you can try to negotiate something different. But in terms of the appraisal process, which sets the base value, which is the key to the whole thing, A, the homeowner gets to choose the appraiser. B, it's at the expense of Invenergy, not the homeowner. C, that list that we put together was, we did a vetting to try to determine the best appraisers we could who had the most information about this community, that were the best respected ones. It doesn't mean that with the agreement of Invenergy you couldn't use another appraiser, but those are the appraisers that were preferred. We were more concerned that Invenergy would try to use an appraiser that we didn't like. So we wanted to make sure that the ones we had attached were good ones that we knew about and that we trusted. So you've got the right to choose it. You've got a right to make them pay for it. It's from a list of people that we've pre-vetted for you. And if you still don't like what happens as a result of the appraisal, you've got a right to demand a second appraisal from another appraiser at their expense, not yours, and then the base value that's established for the agreement becomes the average of the two appraisers. We thought that was a fair process. Again, if you don't think it's a fair process, you can try to negotiate something different. But that's how that process works, and the base value is the beginning part for the whole process.
What is this? What is this? Are you kidding me? Come on.
What's a violation?
There were concerns by a number of people that there were loopholes in the agreement. I can assure the council that I have used my 40 years of judgment in this field, working with Glenn Walker, who has done this for 20 plus years, and we worked very hard on this for a year and a half. We have done everything we can to make sure there are no loopholes. I'll give you a couple of examples of places where it was brought to our attention that there were allegedly loopholes. There were claims, for example, that in the decommissioning agreement, that we should add paragraph after paragraph after paragraph with regard to specifications for the letters of credit, the bond, those sorts of things that should be provided. What the gentleman who made the comment either didn't read or ignored is the fact that instead of listing multiple things that needed to be done, which would have created loopholes, because if they checked each of the boxes, we'd have no complaint. Instead of doing that, we simply made an introductory paragraph that said that all of these financial instruments have to meet the town's prior approval. So we can require anything we want, anything at all. The agreement has shut the door on that. There is no loophole in the agreement to that effect. And all of the comments can be easily answered by a close reading of the agreement, and I'm giving you my professional opinion that these are solid, binding agreements. Yes.
It was asked that Invenergy would change or modify their plans in the course of the EFSB hearings. Would it nullify the tax rate?
Absolutely not. It's 100% binding on them, regardless of what they do. What we did in the agreement is we put it into two sections. The Unit 1 section, which has already been approved by ISO New England, and the Unit 2 section. And for both of them, we negotiated an amount that gives them the right to build a unit of up to 500 megawatts. And we did a valuation assuming that it would not exceed 500 megawatts. Should they exceed 500 megawatts, all bets are off. They will not exceed 500 megawatts. They don't have that approval from ISO New England for Unit 1, and I doubt seriously that they will get it for Unit 2, but if they do, then the Unit 2 agreement is off and we get to renegotiate a new one.
Mike, there was a question regarding the upfront fees that we negotiated into the agreement, and there was a question of whether or not that was a common practice with tax agreements. Is that a common practice?
It's not an uncommon practice. That's fairly common. It's designed to compensate communities for this type of involvement in the proceeding.
I agree with that.
Is the size of the upfront fees that we're getting in line with others, or?
It's in line with other plants of this size. All of the pricing in this is dependent on the size of the plant, and because the revenue that is generated goes up given the larger size of the plant. So it's important to recognize that the tax agreement, while it's called tax agreement at the top, if you read the actual agreement itself, it's in two parts. Part 1 is upfront fees. Part 2 is taxes. And so yes, those fees are meant to compensate the town for all of the involvement that they have to do with this, and there is no restriction, we would not have allowed a restriction on how we use those funds.
The plant in Oxford, there was questions brought up about that being an additional phase in that plan, and that whether the town was looking to negotiate and get a better deal and lost it, or if they just outright rejected the plan and had nothing at all.
Let me try and clarify that. The Oxford site has been under proposal since about 2000. I think Calpine was the original developer down there. In 2000, I helped the town do a pilot for the proposed Calpine unit, which was never built. Excuse me, that unit was probably 500 megawatts. Subsequent to that, Calpine sold the development rights to the current developer, CPB, who got a capacity award, is moving forward with that. The agreement was renegotiated by the town administration, taken to a municipal vote, and the municipal vote shot the pilot down. So
what, do we know why? Whether you know?
I think I talked to the town manager, and his thought was there was some perception that if the tax agreement was denied, that the project would not move forward, and that's not the case. They're moving forward without a tax agreement or a pilot agreement right now.
The plants there in New Hampshire where they have no tax agreements, were those also voted down?
In New Hampshire, we cannot do tax agreements for fossil fuel units, so those projects that were built without the benefit of a tax agreement. They just moved forward.
They came in, so those towns aren't compensated at all?
Well, they're compensated, but they have to fight year to year.
They go into the tax roll?
They go on the tax roll, yeah. And sometimes, I can tell you, in the case of the Londonderry plant, Granite Ridge, I think they had wished they had had a tax agreement because they had spent years fighting over the value of the taxes, et cetera.
This is a little bit of theater, isn't it?
What happens if the should go bankrupt?
Yeah, that's specifically provided for in the different agreements, and the provisions are very similar. Let's look at the tax agreement, for example. If they go bankrupt under the tax agreement, it's what I explained earlier. They're not going to pay their taxes because they don't have any money to pay it. We get to foreclose on the property. I think we'd have no problem selling a $400 million asset for $3 or $4 million in unpaid taxes. But over and above that, as I mentioned earlier, their lenders would step in. So if they went bankrupt, the first thing that would happen is the lenders would come to us. They would want us to let them pay the taxes, and they would probably want us to give them a deed that would then allow them to step in and either operate it themselves for a while or sell it or both. The decommissioning agreement, the problem with the decommissioning agreement, and it's not a problem, the way it's set up is we have these financial assurances that meet our standards at 125% of the value. So we're not looking to Invenergy to provide the financial assurances for decommissioning. We're looking to the financial institution that has guaranteed the situation. So if they go bankrupt, the financial institution has to step in and do it.
Mr. President?
Yeah, I'm sorry.
Oh, I got a quick question on the public safety side of things. Are we able to negotiate anything for the fire districts, considering they're separate entities? And do we know if they're in the process of doing anything to cover their costs associated with this?
If you're asking me, I can say that, to my knowledge, well, first of all, I'm not involved with the fire districts in any way, shape, or form. I'm not negotiating on their behalf. The best I can say is it was my understanding that they're negotiating separately with Invenergy to take care of their interests. I can't, the town can't negotiate for them. They are a separate legal entity.
Okay.
That was a question that was brought up. That's a question that's brought up with first responders and training, particularly for Pasco Fire District, and that's something that we're all concerned about as well, but it's unfortunately not inside the purview of the council because of the way the fire district is set up. They're separate taxing entities.
Well, could I make 2 points on that? The first is that there is nothing to, we're going to, if the plan goes forward, if it's forced on us, and this tax agreement is put into place, we will be getting at a minimum, approximately $100 million over 20 years. Some portion of that can easily be used for this sort of training program. No doubt about it.
It's not continued, it's your vote tonight.
No, but if the town wanted to, it could make money available to do something like that. It's up to the town. If it doesn't feel that it's the town's obligation, that it should be done by the fire district, then that's a political decision that is made. But I'm saying there's a lot of money available that can be used in whatever way the town council thinks is appropriate and is advised by its solicitor is legal. That's a town question of law that I don't have the answer to. The second part is that one thing I do have the answer to is that I advise, some of you may know, I advise the planning board in the planning board process, and one of the things that they recommended in their advisory opinion is that the EFSB make it a condition of the permit that these issues be taken care of by Invenergy. And whether the EFSB will do that or not, I don't know, but we are going to be advocating very strongly for it. Yeah, on the question of whether or not the payment by Invenergy to make up the difference in the event of a base value and the actual sales price, whether or not you would get a 1099 for that. I am a tax lawyer. However, I did not look that particular question up. I can tell you off the top of my head what I think the answer is, but I can't guarantee you that it's the right answer at this point in time. What I think the answer is like any other calculation of whether or not you've had a profit on the sale of your house, that would go into the money that was paid. So what happens when you sell your house is you first look at your tax basis. Your tax basis is essentially what did you pay for the house before and how much money have you spent on improvements. You add those together. If you paid $100,000 and if you added $50,000 of improvements, your basis is $150,000. Then you look at how much you received from the sale of the house. If somebody agreed to buy it for $200,000, but that was $50,000 less than the base value, you would get $200,000 from the buyer and you would get $50,000 from Invenergy, so you'd have that number, which you would subtract the base value, and that number would become your profit on the sale of the house. It's not income taxable. You're talking about whether or not you tax it as a result of the sale. Now, once you determine what your profit is on the sale, the amount you got, Invenergy and buyer put together over what you paid or invested, okay, that becomes the amount that would theoretically be subject to tax, except that Congress every year tends to fool with how much you're exempt from taxes on the sale of your home. As long as you've lived in your home for the required period of time, I haven't looked up the period lately, it's 2 years. If you've lived in there for 2 years, I believe the exemption is $500,000. Last time I looked, it was $500,000. So unless you have more than $500,000 of profit, you would pay no taxes.
What about a 1099 on the $1,500 or $5,000?
Sorry, I think
1099 on the fee that Invenergy is willing to pay as part of the PVGA, the 1,500 or 5,000.
the 5,000 and the 1,500, I believe, would be 1099.
Mike, can you just talk a little bit about when we had initially started the negotiations on the PVGA and looking at the properties that Invenergy originally came to the table with? Can you talk a little bit about the radius and how it expanded from those initial discussions?
Yeah, the radius was a real tough negotiating problem. It was really big. Invenergy is developing plants all over the country, and they usually don't give property value guarantee agreements. We insisted on it. So, okay, they had to do it. So then, we wanted a broad radius, they wanted a narrow radius. I mean, that's the way these negotiations work. So at first we were talking about, they were insisting that it not exceed, under any set of circumstances, a half a mile. We came back to you, as you may recall, and we said in executive session, and I don't think I'm breaking the seal now, but we said to you that they were proposing a half a mile, and you said, no way, that's not enough. Go back and get more. So we went back and we expanded the radius so that it's approximately 3/4 of a mile. It's not exactly 3/4 of a mile. And as we started negotiating the inclusion of different properties, what it essentially came down to is which properties we could make a good argument with Invenergy for that would be adversely affected. Would they be especially affected by like the truck traffic that would be coming in during the construction period?
Okay.
Those are the ones that we focused on. So we initially had a number of affected properties that was...
Come on, we listen to you. Let's be nice.
I would say it was about 35. And the current number of affected properties that we have negotiated them up to is about 115, 17, something like that. And it was a tough negotiation to get them all included.
We need another meeting.
Somebody did bring up the issue of the plant is going to be there for 40 years, but the tax agreement is only for 20 years. The law only allows us to go up to 25 years on a tax agreement. It does allow us to extend it at the end of the 25 for another 20 years on top of that. And so that's the procedure that would be used. But 20 years in these agreements is long. I'm not saying it's never done for 20 years. It is done for 20 years. I believe we did Ocean State Power for 20 years, although I did not negotiate the original one. But we do have the extension available on that as well. And frankly, my feeling is that after 20 years, you really do need to take another look at it. You shouldn't do a 40-year agreement. I would not advise that.
There was a question, and I'm not sure if you can answer. There was a question as to who's going to oversee the environmental impact study. Is that still DEM?
You're talking about in the decommissioning agreement?
Yeah.
One of the things about the decommissioning agreement is, if you read it carefully, the town is a party to and needs to approve everything that gets done in the various estimates that are being made in order to determine how much it's going to cost to decommission it so that we can get the necessary bonding at 125%. The town is included. The town is authorized to hire experts to assist, whether they're engineers, appraisers, whatever they may be, and Invenergy has to pay us to pay our experts.
I don't think that answers the question.
Mr. Wood brought up an important point. I'm glad he did. There was a comment that the agreement was the decommissioning agreement was poorly written because it talked about current EPA and DEM regulations. Well, the word current is there, but it was taken totally out of context. What that provision says is that you've got to update this thing at least every 5 years. And in the 5-year update, you have to use the current regulations. That is the regulations that are in effect at the time of the 5-year update.
Anybody else? Any discussion? Anybody else?
There's no further discussion by the council. I would like to make a motion to reschedule the vote for a time next week to be determined by the council president.
Can I get a second?
Second.
I have a motion and a second. All in favor? Okay.
If November 2nd is not the
Can I,
deadline, it seems to me you
okay.
could delay it even more
Yeah.
until after you
Anybody
have the
opposed?
new town council.
We're in the middle of voting.
Was anybody opposed to that? No? Okay, it was 7-0.
Motion to adjourn.
Motion adjourned in a second. All in favor?